Hello and welcome. My name is Alan. Today we are back with more of the U.S. Constitution. I know I've been away for a while, but it is what it is. Today we will be covering Amendment 4 of the U.S. Constitution. Again, I'll be reading out of my American Constitutional Law book. But yeah, like I mentioned before already, Amendment 4, one of the Bill of Rights. Let's go ahead and read this verbatim. The right of the people to be secure in their persons, houses, papers, and effects against unreasonable searches and seizures shall not be violated, and no warrants shall issue but upon probable cause, supported by oath or affirmation, and particularly describing the place to be searched and the persons or things to be seized. So, yeah, the idea is the cops can't go straight in and say, we think this is proof of this and this and this. They have to have probable cause that they believe something is going on. And we'd like, by law, it'd be preferential that it's particular that they describe what is going on, so that they have to list what place and what they think is there to be seized. That is the only way they can get a warrant to search and seize. Probable cause itself, this is from cornelllaw.edu, law.cornell.edu. Probable cause. Definition. Probable cause is a requirement found in the Fourth Amendment that must usually be met before police can make an arrest, conduct a search, or receive a warrant. Courts usually find probable cause when there is a reasonable basis for believing that a crime may have been committed for an arrest, or when confidence of the crime is present in the place to be searched for a search. Under exigent circumstances, probable cause can also justify a warrantless search and seizure. Persons arrested without a warrant are required to be brought before a competent authority shortly after the arrest for a prompt judicial determination of probable cause. But the overview, there is constitutional basis. Although the Fourth Amendment states that no warrants shall issue but upon probable cause, it does not specify what probable cause actually means. The Supreme Court has attempted to clarify the meaning of the term on several occasions while recognizing that probable cause is a concept that is imprecise fluid and very dependent on context. In the case Illinois versus Gates, the court favored a flexible approach, viewing probable cause as a practical, non-technical standard that calls upon the factual and practical considerations of everyday life, on which reasonable and prudent men act. Courts often adopt a broader, more flexible view of probable cause when the alleged offenses are serious. Application to arrests. The Fourth Amendment requires that any arrest be based on probable cause, even when the arrest is made pursuant to an arrest warrant. Whether or not there is probable cause typically depends on the totality of the circumstances, meaning everything that the arresting officers know or reasonably believe at the time the arrest is made. However, probable cause remains a flexible concept, and what constitutes the totality of the circumstances often depends on how the court interprets the reasonableness standard. A lack of probable cause will render a warrantless arrest invalid, and any evidence resulting from that arrest, physical evidence, confessions, etc., will have to be suppressed. So remember, they can have a warrantless arrest, but they must show that there was probable cause. But more often than not, I think it does require a warrant. And if a warrantless arrest turns out not to have probable cause, anything picked from that will have to be removed, suppressed. A narrow exception applies when an arresting officer, as a result of a mistake by court employees, mistakenly and in good faith believes that a warrant has been issued. In this case, notwithstanding the lack of probable cause, the exclusionary rule does not apply, and the evidence obtained may be admissible to court. Unlike court clerks, prosecutors are a part of law enforcement team and not court employees for purposes of good faith exception to the exclusionary rule. So as long as the officer believes a warrant was issued, if he acts in good faith for that with probable cause, then it doesn't matter if there was no warrant. And it seems to be the only really differential. But yeah, they mention a number of other things here. Probable cause in the digital age, application to search warrants. So yeah. But that's most of what was off that page, the web page itself there. But yeah. Basically the Fourth Amendment is kind of a response to the British coming in and just saying, "This is contraband. You know, this you were going to use this in sort of a crime without any proof." And the court says, "We can't have that happen again." So yeah. But that will be it for this episode. As always, educate thyself, think, read, study, learn. Someone tries to tell you something you have trouble believing, ask them to cite their sources. I'll have the sources to this video in the description below the video. Until then, though, later.